And we will move on to substitute Senate Bill number 55 for its second proponent hearing. The iPads are loading. We will call on Brian Hawkins for proponent testimony. Welcome to committee.
Thank you. Chairman Thomas, Vice Chairman Swearingen, Ranking Member Sonnenberg, and members of the House Judiciary Committee, on behalf of the Ohio Association of Criminal Defense Lawyers, I have the privilege of being here to speak on support of Senate Bill 55. I've spent the entirety of my 15-year legal career as a criminal defense lawyer, and for the last 8 years, I've worked at a firm here in Columbus that specializes in OVI defense and serious vehicular offenses around the Central Ohio region. I'd like to preface my comments by first saying that nobody wants anybody driving on Ohio's roadways impaired, whether that's by alcohol or by drugs. But on the flip side of that, it's equally as important that we need to ensure that our laws are written in a way that avoid punishing innocent people who are no way impaired when they are operating a vehicle. Unfortunately, Ohio's OVI statute, as it is currently written, does just that with regard to marijuana. Under our current law, someone who has not consumed marijuana for weeks or even months could be nonetheless convicted of OVI solely due to the presence of a completely inert metabolite found in their blood or urine. Current Ohio law treats this no differently than somebody testing over the legal limit for alcohol, even though the person is under no impairing effect of marijuana. Well, this has been an issue for many years. The legalization of medical marijuana in 2016 and recreational marijuana in 2023 have made finding a solution to this much more urgent. Senate Bill 55 is an important and long overdue step in bringing Ohio's law in line with existing science and eliminating this inherent unfairness. The crux of this issue comes from the fact that Ohio's OVI statute creates what is called a per se offense. What this means is the statute sets a legal limit for the quantity of a substance that can be found in somebody's blood, breath, urine, and now oral fluid. And if a driver has above that amount in their system, they would be deemed guilty of an OVI, even if their ability to operate a vehicle is not impaired. Most people are familiar with this construct through the 0.08 legal limit for breath for alcohol. For marijuana, there are actually multiple legal limits. For simplicity's sake, the ones that we're concerned with today are the limits of 2 nanograms of delta-9 tetrahydrocannabinol, or THC as it's more commonly known, or 50 nanograms of a marijuana metabolite per milliliter of a person's blood sample. Delta-9 THC is the active psychoactive ingredient in marijuana. It's what creates the impairing effect. Once it is ingested into the body begins to metabolize it into waste products that we call metabolites. I went into more detail in my written testimony, but for today's purposes, the end result of this process creates a substance called carboxy-THC. Carboxy-THC is unanimously understood by the scientific experts to be completely inactive, creates no impairing effect on the human body, and can linger in a person's body for days, weeks, or even months after use. We should be concerned with the delta-9 THC, the active impairing ingredient in marijuana. However, Ohio has a per se limit for these marijuana metabolites. So anybody with over, right now the limit is 36 nanograms in a urine sample of carboxy-THC is deemed to be legally impaired. This would be like charging somebody for an alcohol-related OVI because the officer saw them pull into their driveway and then noticed a bunch of empty beer cans in the recycling bin. At best, it's evidence that they consumed marijuana at some undefined point in the past. So this combination of testing for an inactive waste product rather than an active impairing component of marijuana and then deeming somebody to be guilty of OVI based on that level has led to and will continue to lead to countless people being charged and convicted for operating a vehicle while impaired, even though they were absolutely not impaired while they were driving. Senate Bill 55 has been carefully drafted to alleviate this issue while retaining the state's ability to prosecute defendants with active THC in their blood. It also leaves undisturbed law enforcement's ability to conduct roadside investigations for determining whether a person should be arrested for marijuana-based OVI. The officers developed this probable cause to arrest through application of their training, administration of field sobriety tests, observations of the driver at the roadside. This bill does nothing to impede or alter the officer's ability to do this. What it does focus on is these pro se charges and then a defendant's ability to defend themselves once the case is sent to court. The first thing it does is it sets a new per se limit for the active delta-9 THC in a person's blood sample at 5 nanograms per milliliter and eliminates the per se offenses based off metabolites entirely. It also removes per per se offenses based off urine and oral fluid testing. Those types of testing are not entirely removed from the equation. What this bill does is it creates a new evidentiary standard where the trier of fact, which in most cases is going to be a jury, is able to infer that a person is under the influence of marijuana without having to offer expert testimony if they test at or above certain limits for THC in urine, THC in blood, or THC in oral fluid. Once that inference is established, either party in a case can offer evidence to support or rebut it as long as it complies with the rules of evidence. This bill does nothing to interfere with the rules of evidence at a trial. And it would allow the jury to take all relevant evidence, including those tests, into account when determining whether a driver was actually impaired by THC. OVIs are an incredibly complex area of law that require balancing public safety interests, defendants' due process rights, and scientific standards of what constitutes impairment. It is clear that allowing drivers to be convicted of impaired driving solely based on the level of an inactive metabolite of marijuana in their body is patently unfair. The bill's proposed solutions acknowledge the fact by maintaining per se limits for THC and eliminates the per se limits for metabolites while allowing defendants the ability to rebut the inference of their impairment at lower levels of positive tests for delta-9 THC. This compromise position preserves law enforcement's ability to keep impaired drivers off the road, promotes the state's ability to prosecute drivers who are truly impaired by THC, and protects the due process rights of the accused. Thank you.
Thank you for your testimony. Are there any questions? Representative Williams with a question.
Thank you, Chair. So I just want to be clear. So by removing the per se for the metabolite, we're looking at creating this kind of inference, but it's I just want to be clear, it's not based on the metabolite being present, it's based on actual THC now. That's the proposal in 55, is that there's a level of actual THC that's going to be used by the jury to infer whether or not a person's actually impaired or not?
Through the chair, Representative Williams, thank you for your question. Yes, that is my understanding, is that is based off the actual levels of the actually impairing psychoactive THC in their system. So in blood, there's the per se level of 5 nanograms. If you're above that, it's going to operate exactly the same as it does now. If you're between 2 nanograms and 5 nanograms in blood, that creates this inference that both sides can provide evidence to either support or rebut. Likewise, there's a limit of 25 nanograms in urine and then again 5 nanograms in oral fluid that would create this inference.
Follow up.
So it leads me to the question of like, why are, if we can test for the actual active ingredient of THC compared to the metabolite, why are we getting rid of per se, even though per se still exists for alcohol? Wouldn't we just look at making a certain level of THC per se, whether that level's high, higher, and maintain the structure that we currently have, which is if you're over a certain limit of this active ingredient, you are per se intoxicated? Wouldn't that be like a smoother way of doing it compared to creating this new inference that can, you know, the jury can infer that you're intoxicated and you can rebut it? Why are we going to treat alcohol and marijuana differently for OVI statutes when the entire marijuana industry came into the committee and asked to be treated identical to alcohol? So why are we going to change that for OVIs?
And through the chair, thank you for your question, Representative Williams. So there still is a per se limit, 5 nanograms. Above that, it is treated the exact same way that being above 0.08 for alcohol would be. To answer your broader question as to why it is treated differently, I think a lot of the friction with regards to marijuana-based OVI enforcement is that we've been trying to fit the way the marijuana impacts the body, the way it is metabolized by the body, and the way it creates impairment into the paradigm that we created with per se alcohol enforcement, and it's not a one-to-one situation. The body absorbs it differently, the amounts impact you differently. Alcohol is predictable. We have decades upon decades of science showing you the body absorbs alcohol, it levels off, it goes down. The higher the level in your system, the more impaired you are. Marijuana doesn't work exactly the same way, so trying to fit the round peg into a square hole of just saying, let's do this exactly like alcohol in the situation has created some of the issues we have now where we're testing for these waste products that, again, it'd be like, well, this guy's got some empty beer cans next to his garage. He's driving now, let's charge him with OVI. That just means he drank at some point in the past. So right now we're looking at this waste product in somebody's urine or blood sample and saying, this person consumed marijuana in some form at some point in the past. We don't know when, and depending on a multitude of factors, it could have been weeks ago, it could have been a month or more ago. And we're saying we're treating that exactly the same as being over a .08. And this bill is looking to address that discrepancy.
Yes.
Yeah, so just brief, I understand that part, but as soon as we start getting in a conversation that marijuana is, metabolized differently than alcohol, it has a different effect on the body, we can have that same conversation about cocaine, LSD, PCP. Like, we can have that conversation about every single drug, that it's different than alcohol, it's metabolized differently, it has a different effect. I just don't quite understand why we're going to treat marijuana differently instead of just saying, hey, there's a per se level, here's the per se level. Experts say if there's an active ingredient of THC in your system over this many nanograms, you're per se intoxicated, just like we do with cocaine, with opiates, we do it with alcohol. I don't get why we're going to have this special carve out for marijuana that's different than everything else. And especially, we're going to create this new burden on the trier of fact that we give them information about an inference, which they already get a jury instruction that they're able to make inferences from evidence that's introduced at trial. So I'm kind of losing the idea of why we're creating this special circumstance for marijuana-related OVIs instead of just creating a threshold that we can agree at a certain nanograms it's per se, just like alcohol. That's the situation. It's a per se.
Through the chair, thank you again for your follow-up. Again, Senate Bill 55 does maintain a per se level for the actual active THC. What this bill is mainly addressing is the ability to test for metabolites, which is scientifically, chemically different from the active THC. As it stands right now, we have two separate per se levels for marijuana. There's the per se level for the active THC, and then there's the per se level for these metabolites. So it'd be like if we had, it's for .08 for alcohol, then if we had some other level for an enzyme that your body creates as it breaks down the alcohol. We don't have that for alcohol. We just have alcohol. Right now for marijuana, we have THC and then metabolite. And what this bill is looking to do is get rid of that metabolite and say, look, we have a per se level for the active THC, but we're getting rid of the metabolite. The inference that it creates is a separate issue in that at lower levels of THC, it allows a jury or a judge, if it were to be a court trial, to look at a lower positive test and say, well, this person has some amount, so we're going to take that into account with all the other evidence we've been presented of this person's impairment or lack of impairment, and use that as one piece of the puzzle to determine. I've handled cases in my career where somebody is charged with an alcohol-related OVI who tested under that .08 limit. You can be under .08 and be impaired. It's just the law says if you're above .08, you don't get to say you weren't impaired. You can't argue you weren't impaired. The law says you are impaired. So it basically just shifts marijuana closer to alcohol in that sense.
Follow up?
Thank you, Chair. But under alcohol, when you're under the .08, there isn't this special inference in statute that the jury can infer that you're intoxicated. So that's what I'm trying to understand why we need this additional inference.
So in an alcohol-related case, evidence of a test under the legal limit could be introduced at trial, and the jury could take it into account. The difference is that per se OVI enforcement in Ohio started with alcohol. So everything's kind of built on the backs of that. There is no metabolite alcohol OVI. So there is a metabolite marijuana OVI as it exists now. So we're trying to clean up the discrepancy and create this additional inference to account for that difference.
Any other questions for the witness? Seeing none, thank you for your testimony.
Thank you.
Please note there are multiple written-only testimonies on your iPads, and this will conclude the second hearing for Senate Bill 55. Somebody here for 478? Is she here? I now call up House Bill 478 for its third hearing.